I did notice that the sign-up sheet had a bunch of crossed-off courtroom letters on it, but mine was always here. All right, so we're here with Mr. Josie. I think I got an email 6 o'clock this morning.
Yes, Your Honor.
With a, let me try and get my email open because it's not going to be in the file, I'm sure. But it was a kind of compliance report.
That is correct. My office told me that it was sent to you at 7:08 this morning. I have not read it myself, but they sent me a brief summary. I was driving
It's
here.
pretty brief as it is, but
Okay.
it basically just says that he's shown some minimal gains in the training. Be reevaluated in 6 to 9 months.
I've read that, Your Honor.
You read
Thank
that,
you.
okay.
Yes, sir.
It came in at, yeah. I have it as 6:08, but maybe I got the early version. All right, so what would we like to do with Mr. Josie?
Set it for a status hearing after, between 6 and 9 months?
Yes, I agree.
I would say probably December, just because I don't think the 27 calendar is fleshed out to that point where I know where all my miscellaneous days may be. I could probably figure it out based on what I've got, but I think putting it at give or take 7 months is probably adequate. I would say December 3rd at 9 o'clock for status.
That would be fine, Your Honor.
Thank you, Your Honor.
All right. Thank you, Ms. Henders.
That's all I had before you. May I be excused?
Yes. Have a good day.
Good to see you, Judge.
You too. All right. Is anybody else ready?
Judge, I'm ready on all of mine.
All right. Come on up, Mr. Williams.
Unfortunately, all of mine are incarcerated. Well, I guess there's one that I can call up. Gracie Hardy, Judge. Clerk, I think, still has me on this. The court signed orders allowing us to withdraw. The final order came in yesterday. There's 2 different cases. I emailed RCC and let Scott know about it, so he's aware and will be here at some point today on his cases and can handle her at that time.
Just a second.
And you've got...
Josie Hardy? There it is.
Yeah,
Sorry.
Gracie Hardy,
I've got it.
Judge. Only one of the cases is on for today. There's another case that court's also signed a withdrawal on yesterday, I believe. That case number is 25 CF 1916. And when the court calls Antarius McLean up for his pro se case.
Hold on, what was the case number for the other case?
The current one that I'm showing on the clerk's docket is 2025 CF 2402.
2, but the other one you said.
Oh, the other one I believe is 2025 CF 1916.
That one's not pulling up when I, let me see if I can find it. What is that set for?
I don't recall off the top of my head, Judge. I know we filed a withdrawal on 4/30, and then yesterday you filed the order. Yeah, McLean's pro se. Yeah, but I've got him for an arraignment this afternoon, and I'll just come up and do my thing when he finishes with his.
Are you standing right here? Do you want to be standing right there?
Yeah, just have him come on out.
Stand on that, please.
Hey, Mr. McLean. Mr. Klain, this is the one that you're representing yourself, so I'm going to step back, and then I'll come forward when you finish with that, okay? And we'll do the arraignment for you.
So let's put Ms. Hardy for, what, the 28th at 9 o'clock with RCC? Well, I don't have Mr. Klein's here, so let's just tell her if she you can ask her if she'd like to come out to address the court. I can certainly do that, but she won't have her counsel here.
I thought he was going to be here.
I don't see him yet, But
Yeah,
if he shows up, obviously we can do that, but,
Otherwise, it's April 28th.
May.
That's not right.
Does he have other
I think
cases
my
on the docket?
flaws are wearing off on you. All right, say again.
Does he have other cases on the docket for today?
Okay, we don't need to drag him over if he's in juvenile court, but we can bring her out once he gets here. All right.
Judge,
And this is Mr. McLean.
that's correct.
And you're here in, let me just make sure I get the cases right, 2026 CF 248. Mr. McLean, I think the issue was just whether or not you're going to retain an attorney for this case.
Mom went to seeing Larissa Douglas yesterday.
Okay, and?
She was supposed to hire her yesterday. I haven't got back on the phone, but
Okay.
yesterday she had got. My mom told her she was out of town, so I'm pretty sure she had got him.
Okay. All right, then 6:58 is this afternoon. Do you know if the intent was to hire Ms. Dudley for both cases?
She was gonna do it for both. She. That's why I didn't have all the money, but she was gonna do it for both.
At least in the 6:58 case, which is set for this afternoon, Mr. Williams from the Public Defender's Office is still representing you at this point. What would you like to do with that case today?
Judge, I'm just going to enter a plea of not guilty on his behalf, 15 days for arraignment motions, trial by jury.
Okay. All right, so for the 6:50, well, let's put, has he entered a plea on 248? I'm assuming so. A while back. Yes. All right, so let's put them both on June 24th at 9 o'clock for your pretrial conference. The reason I've been bringing you back is so we didn't get to a point where you didn't have a lawyer until June 24th. If something doesn't work out with private counsel, you can certainly ask for a public defender to be appointed to you in your 248 case. As of now, Mr. Williams is still on it, but just make sure that whoever's going to be representing you communicates with his office and tell him to kind of stand down, that they're going to be working on the case so he can stop. All right.
We'll withdraw once we get a notice of appearance from lawyers.
All right. Thank you, Mr. McLean. We'll see you on June 24th.
Thank you, Judge.
Oh, okay. And he's received the information and plea of not guilty has been entered.
And I have Miss Hardy right here.
Oh, Mr. All right, Mr. Kleins, this is Gracie Hardy. I think I signed an order appointing you yesterday.
And Mr. Williams had informed me that I was going to be representing Miss Hardy. I was down in the juvenile courtroom with Judge Gonteric. I was going to talk to Miss Hardy.
And it wasn't my intent to have you pulled over for it, so I
mean,
just that if you were going to be here later this morning, that you could have a chance to maybe speak.
I was going
with
to
Ms.
ask if we
Hardy.
could pass her so I can get back down there, and then I'll come talk to you.
All right, so let's leave Ms. Hardy back there so Mr. Kleins can talk to her once he's finished up with delinquency court down the hall.
Perfect. Yeah, well, I mean, I'm going to have her brought back out. I don't even know why she's here. Like, I don't know if this is an arraignment or what, so I'll come talk to you in about 20 minutes.
All right. Thank you. Thank you, Mr. Kleins.
Mr. Williams, I have two lined up for you.
All right.
Go on, please, Judge.
Judge, give me just 1 second. Grab Mr. Mattingley's plea agreement.
Okay.
Plea. State of Florida versus James Mattingley, 4625 CF 1642. Judge, this is a slight downward departure, I believe.
It is what? I'm sorry.
Maybe it's not. I'm thinking of somebody else, Judge. Never mind.
All right, this is
No,
Mr.
it is. It's a slight downward departure.
Not as slight as it gets. All right, Mr. Mattingly, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Can you state your full name and date of birth, please?
My name is James Brandon Mattingly, 11/27/1982.
All right, and Mr. Mattingly, you're here in 25 CF 1642, where you're charged with aggravated assault by threat with a deadly weapon, which is a third-degree felony and punishable by up to 5 years in state prison. Do you understand that?
Yes, Your Honor.
All right, and I've been handed a plea and sentencing agreement that would have you plea as charged, so adjudicate you guilty, so that'd be a felony conviction. 11 months, 29 days in the Okaloosa County Jail, credit for time served, $967 in court costs, $150 PD fees. Says no contact with the victim.
Yes, Your Honor.
All right, is that your understanding of the plea and sentencing agreement?
Yes, Your Honor.
All right, and is that the state's agreement? All right, it's a very slight downward departure. He scored 12.225. All right. All right. All right, Mr. Mattingly, did you have enough time to go over this plea form with your lawyer?
Yes, I have, Your Honor.
Did you understand and sign that agreement?
Completely, Your Honor.
All right. And did you, are you satisfied with your attorney's advice and representation in this case?
Yes, I am, Your Honor.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
That's a negative, Your Honor.
All right, and are you currently suffering from any mental health issues?
No, Your Honor.
Anyone force, pressure, or threaten you in any way to enter this plea?
Absolutely not.
Has anyone promised you anything other than the terms of the agreement that I've read to you?
No, Your Honor.
You understand by entering a plea there won't be a trial of any kind?
Yes, Your Honor.
And do you understand that you're giving up your trial rights, which start at the bottom of page 1 and go on to page 2 of that agreement that you said you understood and signed?
Yes, Your Honor.
All right, do you understand that you're waiving all potential defenses that you may have?
Yes, Your Honor.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, Your Honor.
And what is your plea as to the aggravated assault with a deadly weapon?
No contest.
I'll accept your no contest plea. It's freely, voluntarily, knowingly given. Adjudicate you guilty. 11 months, 29 days in the Okaloosa County Jail. Credit for time served. $967 court costs. $100 PD fee and no contact with the victim. I need you to be fingerprinted, Mr. Mattingly. You have 30 days to appeal the judgment and sentence of the court. This
Thank
is
you,
a
Your
downward
Honor.
departure ever so slightly due to the fact that it was an uncoerced, legitimate plea bargain. Thank you, Mr. Mattingly. You can be
Thank you, Your Honor. You have a wonderful day.
All right, I'll do my best.
Mr. Knight?
Judge, this is Tommy Knight, 2025 CF 2009. Judge, I tendered a counteroffer to the state this morning.
That's correct.
Is the state inclined to accept that?
Not at the moment.
Okay, so what would you like to do with Mr. Knight for today?
Judge, just put him back on the trial docket. He was previously arraigned and.
It was a VOP, so do you just mean, do you want an
It's-
evidentiary
it's-
hearing to be
It's
set?
actually not a VOP, Judge. I believe it's a failure to appear from back in either January or February.
January 5, it was a failure to appear. The docket says it's a VOP arraignment, however, it's not.
Okay.
My file doesn't reflect that he ever entered a plea.
Nope, I believe you're right, but I'm reading what the docket says on it, so
Yes, sir.
I should have known better. All right, so we'll put that for what, June 24 at 9 o'clock for a pretrial conference.
We can't negotiate in front of the judge in this division, so what I'll do is I'll talk with him about it,
That
and
should happen in any division. But
we'll bring you back if he agrees, okay? All right. Keep him for a
I'll-
little bit.
not that I'm eavesdropping, Mr. Williams, but if y'all want to continue to negotiate and bring him back later today, you can certainly do that, but it's not going to be a situation where it's going to go on in the well.
Yeah, yes, sir.
We've got other cases to handle.
That's what I was trying to explain.
Okay.
And the reason for the state's response is because there's victims in the case.
Understandable.
What he asked about was 3 years.
You have one out of custody, Your Honor.
You got a break? Okay, you can take your out of custody, and then we'll go with your in custody, Mr. Maddox.
Cecil Espino?
Espino.
That's
Espino.
No, it is Espino, okay.
I think you just kind of put an extra syllable in there. So.
Your Honor, we did negotiate a PTI in this case.
Okay. Is that with a plea?
No, it's not.
Okay, let me just take a look at it.
Yes.
Looks like it's been signed. I'll give it back to you, Mr. Maddox, just looking at the terms. All right, we're going to take Mr. Espino off of the docket. Make sure you talk to probation who's sitting there. They're going to be supervising you during the course of the pretrial intervention program. If you successfully complete it, you never have to come back to court for this case, and the case will be dismissed. However, if you don't successfully complete it or fail any of the terms, you'll have to come back and readdress your case. All right. Thank you, Mr. Espino. Talk to probation on your way out.
Start probation, thanks.
Mr. Brown?
Your Honor, this is Mr. Brown before the court in 25 CF 1828. We have reached a resolution in this matter from the approach.
May approach.
Amended information was filed in this.
That's what I'm looking at right now. Thank you, Mr. Maddox.
Yes, Your Honor.
All right, Ms. Leone, anything that you wanted to state?
Oh, no, Your Honor.
Okay. All right, Mr. Brown, can you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Jacob Wesley Brown, 10/17/2005.
All right, and Mr. Brown, you're here on amended charges of child abuse, third-degree felony, and unlawful use of a two-way communication device, also a third-degree felony. Each of those charges are punishable by up to 5 years in a state prison. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement that calls for you to plea as charged to those 2 counts on the amended information filed on the 5th of May, so 2 days ago. The agreed-upon resolution between you and the state would be a withhold of adjudication, no unsupervised contact with any minors during your 3 years of probation, which would be concurrent between the two charges. You're to have no contact with KNR or her immediate family, no use of intoxicants to access or possession of any controlled substances without a valid prescription, substance abuse evaluation, any recommended treatment, psychosexual evaluation, and any recommended treatment. Court costs, is that $666? I'll come back to that. $150 cost of defense and a waived cost of supervision. And this appears to be a guideline sentence as the score is 39.8 points.
Yes, Your Honor.
All right. Is that your understanding of the agreement, Mr. Brown?
Yes, sir.
Is that the state's agreement?
It is.
Anything the state wants to put on the record as to that agreement?
No, only that the state has considered all the obligation under Marcy's law.
Okay. All right, Mr. Brown, did you have enough time to go over this plea agreement with your lawyer?
Yes, sir.
Did you understand and sign the agreement?
Yes, sir.
Are you satisfied with your lawyer's advice and representation in this case?
Yes, sir, I am.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I just read to you?
No, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir, I'm not.
Are you currently suffering from any mental health issues?
No, sir.
You understand by entering this plea there won't be a trial of any kind?
Yes, sir.
And do you understand that you're giving up your trial rights, which are on page 2 of the plea form agreement that you signed and said you understood?
Yes, sir.
You understand that you're waiving all your potential defenses?
Yes, sir.
And you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
And what is your plea to the counts of child abuse and unlawful use of a two-way communication device?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given, withhold adjudication, 3 years of probation concurrent between the two charges, no unsupervised contact with any minors, no contact at all with KNR or her immediate family, no use of intoxicants to excess or possession of any controlled substances without a valid prescription. You're to complete a substance abuse evaluation, any recommended treatment, complete a psychosexual evaluation, any recommended treatment. Court costs? $666 in court costs, $150 cost of defense. I'll waive cost of supervision due to the fact that you've been found to be indigent. And you just speak with probation, who's sitting there behind you, and then you have 30 days to appeal the judgment and sentence of the court. This is a guideline sentence.
Yes, sir.
All right,
Real
thank
quick,
you.
it is the, let me just look at the information. So level 6. All right, just want to make sure the level didn't change with the change in charge.
Appreciate
All
that,
right.
Your Honor.
All right, thank you, Mr. Brown.
Yeah, no, I'm going to talk to you. Yeah, we're good. All right, Your Honor, this is Mr. Cato before the court in 25 CF 970. Your Honor, will enter denial today.
All right, what would you like it set for?
5/28 without subpoenas, Your Honor.
All right, May 28th, 9 o'clock, without subpoenas.
Thank you, Your Honor.
See you back on that day, Mr. Cato.
I think that's all I have this morning. Okay.
That was the last one I saw for you, Mr. Maddox.
Thank you, Your Honor.
Mr.
I
Williams?
believe that's all my business with the court this morning as well.
Okay. Ms. Rivers?
Have one with Marty Notes.
Mr. Thompson?
Same person.
All right. Has anybody heard from Mr. Nopes today?
Marty.
I know where Mr. Nopes is.
Okay.
From him yesterday, as the court knows, Mr. Nopes is busy. He's in, I think he's in Walton County. This morning, he said he was going to rush over here just like last time, as soon as he could.
This docket usually takes a lot longer than 34 minutes, but
Correct. So
especially when we started 5 minutes late or more. So
I will proffer that I don't believe we're going to have a deal today,
okay.
based off of actually the conversations with Mr. Nopes and Ms. Rivers. It's just not.
Your Honor, he's just now leaving Walton County.
So it's going to be 30 to 45 minutes before he's here. Do you want to see if he has any objection to the case just being moved since there's not a deal, Ms. Rivers? Then we'll bring up Mr. Thompson. Mr. Thompson.
Hi, Your Honor.
And I'm just waiting for his response, Your Honor. Your Honor, this is Ralph Thompson before the court on 25 CF 2020, 25 CF 2021, 25 CF 2309. He also has with Mr. Nopes 24 CF 1715, 24 CF 2620, 24 CF 2641, 24 CF 2675, 25 CF 0399. We had thought we had reached an agreement, Your Honor. We have not. I've spoken with Mr. Nopes via text, asked him if he had any objection to us putting his case on another date. He's indicated he does not. As the court is aware, he has just left, is just now leaving Walton County Courthouse. So at this time, we're just requesting.
Mr. Thompson, what we can do is we can move your cases to another date. Mr. Nopes is on his way, but it's just going to be a little bit of time before he gets here. From what I've been told, that there's not going to be a resolution to all the cases today. So we can keep you around for when Mr. Nopes gets here because he has at least one other case that's not yours. If you'd like to address the court with him present.
No, sir, I'll just come back on when we get her,
All right. When would you like it to be, Ms. Rivers?
The next pretrial conference?
June 24?
Yes.
All
And then
right.
if we have anything before then, we'll let you know, Your Honor.
All right, June 24th at 9 o'clock for pretrial conference. And if they get something worked out, we probably have a few court dates we can squeeze you in before then.
Yes, sir.
All right, thank you, Mr.
Thank you, Your
Thompson. Have a good day.
God bless.
Thank you. You too.
Excuse me. Hey, Landon, you want to do the?
Mr. Williams is here, but he's speaking in the hallway.
Charles Williams.
Judge, could we address the case that's set for pretrial detention?
I didn't see that there was one.
I wouldn't, I'm just making sure that she doesn't get, if she is in jail, which I can't see if she's in jail right now. I didn't. If she's in jail, I want to make sure that if she does get transport, or doesn't get transported pretty much. She's got a bond already.
And to whom are we referring?
Miss Krajeg.
I don't have the docket in front of me.
How about a case number?
Yes, that's better.
Sounds like the case number is going to be easier to spell.
I believe there's a case number.
Pretrial detention docket, so I can't see it on.
And I don't recall one ever being sent to me.
the case number, Judge.
All right.
26 CF 834.
State and I's understanding that a bond has been set for her, Your Honor, at this time.
All right. What I see is that there was a MHE done, right? And then, looks like the first appearance judge signed yesterday giving bonds and pretrial services and some conditions, but also says 72 hours for the state to file a pretrial detention motion. That was dated yesterday, so.
That's correct.
I was present for that first appearance hearing while Mr. Hall was on Zoom, and the judge.
You were there the whole time?
No, I was not, but I did happen to see this hearing. Judge Reed announced.
When you say so, because Mr. Hall was also appearing in front of me covering for Judge Ward.
Yes, Your Honor,
So.
I heard about that. Judge Reed announced that pretrial detention would be today.
Okay. What's the state plan to do?
The state's not going to be filing pretrial detention. The state's fine with
Okay.
the bond that was set by the first appearance judge.
What we need is something that's going to be put in writing so the jail knows that.
I can
you're
get an
not-
order.
Okay, get me an order today, otherwise she's gonna probably sit there for at least 2 more days.
Yes, Your Honor.
That's just how I'd expect.
I agree. I'll get an order.
That's the only reasonable reading of what's been filed at this point.
I agree. I'll get an order to the court as soon as I get back to the office, write it up. What was the bond?
Because
So
I
I'll
can
be able
tell
to
you,
pull it up.
it was, I've never received any order saying it was gonna be a pretrial detention motion today.
Okay.
So, I didn't prepare the normal, or my office didn't prepare the normal order that I have ready for if there is gonna be a pretrial detention hearing.
Yes, Your
You
Honor.
can sign that, so, I just wanna make sure it gets done so your client gets an opportunity to be released pursuant to those conditions.
Yes, Your
That's
Honor,
the
I will
state's
do so.
concern, too.
All right. Because we don't even have a clerk minute sheet because no one ever told us it was supposed to be a hearing today.
That is why we are addressing it this morning,
I
Judge.
appreciate that, Mr. Sprouse. I'm
I think it's clear at this point, but yes, the state relayed that they weren't going to file a pretrial detention motion. Our understanding was that it was going to be today, and we just wanted to make sure that we cleared these things up.
The order will be stipulated.
Excellent.
As long as you consider it over to be perfect.
I was called stipulated order setting bond pursuant to first appearance order signed 5/6/28.
Yes, Your Honor.
Okay.
And to clarify, we'll just talk about it. I don't need to do this in front of Your Honor.
It's okay.
All right. Do you prefer I just go ahead and send it in or bring a copy this afternoon for Your Honor to sign?
I would bring it in, to
Okay,
be
I'll bring it
honest. Because my assistant is out, and I don't want it to get stuck
Okay.
in a portal or in her email and not get signed.
I will bring it in.
All right.
I'm not going to be here this afternoon, so.
The state's position's been expressed. All right, has anyone seen Mr. Garrett?
I spoke to him this morning. He had a doctor's appointment in Miramar Beach. I told him that we have gotten the transfer done, so.
The transfer, oh, it's being transferred to,
county court.
okay.
We do have that. I just looked at, I couldn't find it on the clerk's site, but I do have the paperwork.
It just hasn't been processed yet.
So I told him,
Okay, so Mr. Scarborough is going to be in county court?
yes.
All right. Scarborough's been transferred to county court. We'll take it off our docket. And we just have the one other with Mr. Nopes. We have Jonathan O'Shea with Powell, I believe.
Is that O'Shea?
Oh, it's Malprost. All right. That makes that one easier. Okay, dismiss that case. And then we have Charles Williams with Mr. King. Okay. From the sounds of it, Mr. Nopes is probably going to take a little longer to get from Walton County. It sounds like it's coming down pretty good out there right now.
The 1:30. She's represented by Jay Williams.
But Jay's gone.
Still in the building.
If you could call him back up, sure. Anything we can take care of, you know me. I appreciate it. Who else do we have? We've got.
Kyle Palmer is sitting back there. So
That's
he's waiting tomorrow.
Mr. Nopes, and we're about to. Her name, what's her name? Howell, Hannah Howell? All right, Ms. Howell, you're here in 26 CF 648. You're here about 4 hours early, which is fine.
I'm sorry, I
No.
thought it was 8:30 this morning.
No, it's fine. I
Which
just wanna make-
technically I'm running a little late, so it might be a good thing.
I think when the judge says you're early, don't respond with, I thought I was late. So, all right, let me see here.
Being honest.
Do we have information? All right, Ms. Howell, you're charged with possession of a controlled substance, which is a third-degree felony, and possession of drug paraphernalia, a first-degree misdemeanor. You've been handed information of that charging document. Mr. Williams from the PD's office is here to represent you. Mr. Williams?
Judge, I'll just go ahead and enter a plea of not guilty on her behalf. 15 days prior motions trial by jury, unless you've got something you want to announce.
The offers a withhold and 2 years probation.
Okay. With the 2 years probation, probably you and I should talk first. Okay?
Well, let's put it on the next pretrial available, which is going to be June 22nd at 1 p.m. That's in the afternoon.
I remember that, 1 o'clock.
Okay, 1 o'clock. Make sure you stay in touch with Mr. Williams, and we'll see you back on that date.
Okay, thank you.
All right, take her off the 1:30 docket.
Mr. Williams, can Knight go back to jail, or he'll?
He can. Basically, the way that I left it is I asked Mr. Sprouse if he gets time, call the officer, see if that's acceptable. If he doesn't, if he does, we'll bring him back. Otherwise, we'll put him on an earlier day when we find out, what the end result is of it. But at this point, it would be, Mr. Sprouse wouldn't be able to make or agree to the offer. He'd have to run it past the officer. Yeah. And I've explained that to Mr. Knight. Okay.
Who's the other guy back there?
Those guys.
Or juvenile, okay, gotcha. And
Waiting on Marty to get here.
yes, sir. I can take a recess while they're getting things done. I'm not in a hurry.
Harris.
He's on there. Someone asked me about that yesterday. Oh, Paris. On Paris, which is 09CF2515, it's a violation of probation. Bhopal's office contacted my office yesterday to ask if they needed to be here, since he put in a written plea or a denial. And my response was, well, we need to know what you want to set it for, and I don't think I heard anything after that. Since he's not here, I'll go ahead and set him for May 28th at 9 o'clock without subpoenas. Yeah, I guess. As are Klein's. Just make sure, tell Klein's to take his time over there. All right, we'll be in recess until they get back. I'm going to go to my office and do other work. All right, perfect. Thank you all.
All rise, please.
L. King. That's 25 CF 1500. And today, Your Honor, Mr. King is going to withdraw his previously entered not guilty plea and plead no contest to the count, which is child abuse without causing great bodily harm or permanent disability or permanent disfigurement, which is a third-degree felony punishable by up to 5 years in confinement and a $5,000 fine. He is going to be sentenced to 12 years and 1 month in the Department of Corrections.
12 months and 1 day.
12 months and 1 day, I'm sorry. I knew it was a 12 and a 1, my bad. Credit for jail time served. That's
It's
gonna be
okay when he
followed-
says it wrong. It's not good if I say it wrong.
Oh, it still made me panic a little bit.
Okay.
Well, it's early in the morning, would help us all get awake. It's going to be
I wouldn't
followed-
call it early anymore,
Well,
Mr. Williams.
Right. Followed by, that term in the Department of Corrections is going to be followed by
12.1 months.
4 years of probation, Your Honor, during which time he'll complete a parenting class, a batter's intervention program. The contact with the victim, which is his son, Your Honor, will be as permitted by the dependency court judge. There's a dependency case going on. And if reunified with his children, he will have no physical discipline of his children will be allowed. If I could, I'll pass this.
Please. You have a score sheet as well?
To you and a score sheet as well.
Thank you.
And Your Honor,
Is there a pending dependency case somewhere?
Your Honor, I wasn't able to look it up. It doesn't show, but Mr. Williams assured me that he actually participated in one of the hearings for the dependency case.
I didn't actually, participate. I was at, with Judge Gontrak and.
I mean, you were
Court
present in court.
when his case was called. when
Yeah.
Mr. King's case was called. He's represented by Attorney Stephen Ryan.
Ryan.
Yeah. And I do have one other request, Your Honor, while you're, and that is.
Give me a minute to verify some other things first.
Very well.
Excuse me. I think that was it. Your first name is spelled 2 different ways with the apostrophe, Mr. King. That's why when I looked you up, based on your name is how it's spelled here, it wasn't showing up, but I found it now. It looks like y'all just had court recently. What would you like to add, Mr. Williams?
The one request that Mr. King would like to make is if you accept his plea and sentence him as we've outlined, Your Honor, that he be allowed to, a day or two, to get his affairs in order before he begins his sentence.
Didn't we specifically set this for today for this plea?
We did, Your Honor.
So why weren't those things done previously?
Main thing he's worried about, Your Honor, is getting his paycheck, which he gets today, to the mother of the children to make sure they have some financial support. Get that financial support.
Approach, please. All right, Mr. King, we were set from April 29th to today. It was special set for this date for the plea. I understand you're getting paid today, but there's also other ways to take care of that. Based on my reading of the judge's order from your dependency case this week, the court has moved or inclined to grant that request to turn you in later than today. I just want to make sure I'm telling you that before you enter your plea. All right. Does that change your mind as to what you want to do here today, Mr. King?
A little bit, yes.
All right. Well, does it change your mind or does it not change your mind? It's kind of a either or. It's not, there's no spectrum here of, I kind of want to do this. You either have to want to knowingly, intelligently, voluntarily waive your rights and enter a plea, or you've got to set your case for trial. Okay, well, I'm not going to make any comment on that. Mr. King, raise your right hand. Do you swear or affirm the testimony you're about to give us the truth, the whole truth, nothing but the truth? Can you state your full name and date of birth, please?
06/25/91.
All right, Mr. King, you're here in 25 CF 1500, charged with child abuse without causing great bodily harm, permanent disability, or permanent disfigurement, punished by up to 5 years and a $5,000 fine as stated by your lawyer. Do you understand that charge?
Yes, sir.
All right, I have the terms of a plea and sentencing agreement between you and the state that would call for you to plead no contest to that charge and return an adjudication of guilt, which is a felony conviction. You're to serve 12.1 months in the Department of Corrections, followed by 4 years of probation. Your probation would begin upon your release. You'll get credit for any jail time that you've served against your 12.1 DOC. You're to do a parenting class, batterers intervention program. The contact with the victim in the case will be as permitted by the dependency court judge. And that's 25 DP 273 is the court case on that. If you're reunified, and I'm sure this would be part of any order from that court, is that you're not to use any sort of physical discipline against any child that is in your care. Do you understand that? All right. Have you had enough time to go over this agreement with your lawyer?
Yes, sir.
Did you understand and sign the agreement?
I did, sir.
Is this the state's agreement?
It is, Your Honor.
All right, it's my understanding this is a downward departure.
Yes, Your Honor, and the reason are for an uncoerced plea and also a need of treatment and need of supporting the minor child.
All right, Mr. King, are you satisfied with your attorney's advice and representation in this case?
Yeah. Yes, sir. Sorry.
It's all right, just want to make sure I'm understanding you. Everything's being recorded. It has to be for purposes of a transcript and a yeah. Does it
I
sometimes,
apologize, sir.
Mr. King, if I could finish. Same reason why. The recording doesn't work as well if people don't say things specifically, but also if we interrupt each other. So that's why I want to make sure everything is being recorded in case you have some concerns down the road about your appealing anything that's happened, or you need a transcript from this hearing for whatever reason. I want to make sure it's clear. Okay. All right. So, Mr. King, you stated that you don't have any concerns with your the representation of Mr. Williams. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement that I've read to you?
No, sir.
Do you understand by entering a plea there won't be a trial of any kind? Do you understand that you're giving up your trial rights, which are on page 2 of the agreement that you stated you understood and signed?
Yes, sir.
And do you understand that you're waiving any potential defenses that you may have?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country? Based on that, Mr. King, what is your plea to the one count of child abuse?
No contest, sir.
Accept your no contest plea is freely, voluntarily, knowingly given. Adjudicate you guilty, sentence you to 12.1 months DOC, followed by 4 years of probation to begin once you've been released. You will receive credit for any jail time that you have served against your 12.1. Parenting class you must complete, also batterers intervention program. Have you begun those already?
I have not. I actually have an appointment with, I had an appointment for Bridgeway for my first appointment for therapy on Tuesday the 12th.
Okay. All right, contact with the victim in the case. Your child is permitted only as pursuant to the dependency court in 25 DP 273. If you are reunified with the child, you're to use no physical discipline against that child or any other child that's in your care or custody. All right, court costs. $666 in court costs. Were you appointed or is this privately retained? $150 PD fee. I'll waive cost of supervision due to the fact that he was found to be indigent. This is also a downward departure based on the reasons stated by the state, uncoerced plea bargain, need for treatment, and need to support his minor child. All right, anything else from probation? I covered it. Okay, thank you.
Thank you.
I'll eventually get to everything. All right, Mr. King, I'm still addressing you. If you could talk to probation before you leave, or do you want fingerprints first? Talk to probation, then I need your fingerprints. You have 30 days to appeal the judgment and sentence of the court. Good luck to you, sir.
Thank you, Your Honor. That concludes my business.
12.1 months, or does it
It's
matter?
12.1 is what it needs to be in there. Thank you, Mr. Williams. All right. Mr. Kleins, are you next? Is this Mr. Moore?
Yes, whoever got first.
I can tell you, despite what you told me yesterday, I still went and started reading everything, and then I got your email saying, hey, that we're going to resolve that. So,
It was an interesting argument put forward by Mr. Maddox.
it's a strange statute.
It is. I didn't even know it existed until I read the motion, and I was like, okay, like.
So I'll stop there. I want to see if I'm giving some sort of indication as to what I think about it. All right, this is Ms. Hardy.
It's Ms. Hardy. Signed and dated. Today is May 7th. Your Honor, this is Gracie Hardy. She is signing a plea agreement right now to resolve two cases. She currently has an active felony case. Today is May 7th. She also has a misdemeanor case, and I'll give the court those case numbers here in 1 second. That is going to be 25 CF 2402 and 26 MM 1172. The state is agreeing to resolve both of these cases at the same time. In 25 CF 2402, Ms. Hardy is going to enter a no contest plea as charged. The agreed upon disposition on that case is going to be 2 years of probation, a substance abuse evaluation, and any recommended follow-up treatment. She'll be assessed $615 in court costs, $150 for the cost of defense. The state will take no action on a failure to appear in that case. In 26 MM 1172, Ms. Hardy is going to enter a no contest plea. Mr. Sheik has filed an information for one count of petty theft. She will be entering, and the dollar amount on this is going to be.
When was that, the information? I don't see it.
I filed it this morning, Your Honor. I sent it, Ms. O'Malley is she sent me a response saying that she's filing it.
Okay.
So it might take a second to get, but it is filing today.
And what is it for, petty theft?
Just the
and
petty
resisting?
theft, Your Honor.
Felony, or I'm sorry, second degree misdemeanor. Let me announce the terms on that. It's going to be 6 months probation concurrent to the 2 years of supervision on the felony case. There's going to be a $50 cost of defense, $27 in restitution to Walmart, and she will have no trespassing at Walmart. I have advised and instructed Ms. Hardy that she only has 6 months to make that restitution payment and pay those court costs. But it is concurrent, and it would resolve the only cases that she has pending. There would be a withhold of adjudication. I think that's it, I believe. Oh, no.
And Your Honor, as part of this plea, the state is going to be dismissing 25 CF 1916, which is the other felony case.
Okay.
May I approach?
Yes. Which is the one that doesn't seem to pop up anytime I search for it.
Correct, Your Honor.
The 1916 is still on the score sheet.
Yes, Your Honor, I think.
You want to adjust that while I
Yes, Your Honor.
go through the plea colloquy?
Thank you.
No problem. Thank you, Mr. Sheik. All right, Ms. Hardy, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth, please?
Gracie Olivia Hardy, 6/2/2000.
Okay, and Ms. Hardy, as stated, you're here in 25 CF 2402. You're charged with introduction of contraband and possession of controlled substance, each of which are punishable by up to 5 years in state prison and a $5,000 fine. You also have 26 MM 1172, which is 1 count of petty theft, a second-degree misdemeanor punishable by up to 60 days in county jail and a $500 fine. Do you understand that?
Yes, sir.
Now, you have the third case, which is not going to be part of this plea agreement, but the state has agreed to dismiss it as part of it. Do you understand? Okay. And that was just another possession charge, right?
Correct, Your Honor.
Okay, that's what was on the score sheet. That's what I noticed. All right. Now, your attorney has announced the terms of the agreement. Did you understand those terms?
Yes, sir.
Did you have enough time to go over those terms and the terms of this full agreement with your lawyer?
Yes, sir.
Did you? I'm sorry.
I'm sorry, yes, sir, I did.
I interrupted you. That's my fault. Did you understand and sign the agreement?
Yes, sir.
And are you satisfied with your attorney's advice and representation in this case?
Yes, sir, I am.
All right. And are you currently under the influence of any alcohol, drugs, or controlled substances?
Yes, sir.
Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea?
Yes, sir.
Has anyone promised you anything in return for your plea other than the terms of the agreement that were announced?
Yes,
And do you understand by entering a plea there won't be a trial of any kind? Do you understand by entering a plea there's not going to be a trial?
Yes, sir.
And do you understand that you're giving up your trial rights would start on page 1 and go on to page 2 of the agreement that you've stated you've understood and signed?
Yes, sir.
And do you understand you're waiving all potential defenses that you may have?
Yes, sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right, and this is a withhold on all counts, correct?
Yes, sir.
All right, so no felony convictions for state purposes. However, the petty theft will still require the fingerprints.
May I approach, Your Honor?
Yes, sir.
Thank you.
Thank you. And Ms. Hardy, what is your plea to the introduction of contraband, possession of controlled substance, and petty theft?
No contest.
I'll accept your no contest plea is freely, voluntarily, knowingly given. In 25 CF 2402, it's going to be 2 years of probation, withhold of adjudication, substance abuse evaluation, any recommended treatment. 615 court costs, 150 costs of defense. State's not going to take any action on your failure to appear. In 26 MM 1172, it's going to be 6 months of probation to run concurrently with the 2 years you have on the felony. Court costs on that would be $270 for a misdemeanor, $50 cost of defense, $27 restitution to Walmart, no trespassing at Walmart. And state have an announcement as to the other case.
So for, is it 19, for 25 CF 1916, the state is filing a null pros on that one. And the second charge of 26 MM 1172, the resisting a retail merchant, we are no prosing that one, and we did not file on it. And to let the court know, the 26 MM 1172, it was filed at 10:53 this morning, so it is going through the process.
It's officially filed. All right.
Yes, Your Honor.
All right, Ms. Hardy, I need you to speak with probation, who's sitting back behind you there. I also need you to be fingerprinted for purpose of that petty theft. It is an enhanceable crime if you get more convictions of it. And then you have 30 days to appeal the judgment and sentence of the court. This was a guideline sentence as she scored based on the hand amended guidelines 24.6 points. Did you have any objection to that amendment?
No, I don't have any objection to that.
All right, thank you, Mr. Klein. Thank you, Ms. Hardy. Step back and talk to probation.
If that was probation on each count concurrent.
Yes, each count concurrent.
Go ahead and sign and date it.
It's a security issue.
Your Honor, this is Mr. Moore. He has reached an agreement to resolve these three cases with the state. And the two VOP cases, that's 1357 and 1358, Mr. Moore is going to enter an admission of violating supervision. In 28 CF 2894, he's going to enter a no contest plea to count one. In exchange for that, count two will be no prost. The agreed upon disposition on the VOP cases is that his supervision would be revoked and terminated. He would be sentenced to 17.4 months in the Department of Corrections with credit for all time served. Be assessed $100 cost of defense for each case, $100 cost of prosecution for each case, a $50 application fee. In 24 CF 2894, Mr. Moore would be sentenced to 17.4 months in the Department of Corrections with credit for all time served. These sentences between these three cases are all coterminous and concurrent. He would be assessed $615 in court costs in the 2894 case and $100 cost of defense, and he has not previously been adjudicated, but he will be adjudicated today.
All right.
May I approach?
Yes, sir. Thank you.
Just so Your Honor's aware, this is a negotiated now departure. The score sheet shows 19 points, I believe 4 or in that neighborhood. This is a negotiated downward departure for the state.
And we're from 19.65 to 17.4?
Yes, Your Honor.
What's the basis of the 17.4? I guess I'm just curious.
It was an original, we had originally talked about that number, and that's the basis. I know, it's one of the.
I'm just curious, it's, if it went down to some round number or whole number, or whatever you want to say, I'm just kind of curious. All right, Mr. Moore, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? You state your full name and date of birth, please.
Jeffrey Moore, October 28, 1992.
All right, Mr. Moore, as announced, you're here in two violations of probation, 24 CF 1357 and 1358. You also have 24 CF 2894, where you're charged with aggravated animal cruelty and possession of a controlled substance, both of which are third-degree felonies punishable by up to 5 years in state prison. Do you understand that?
Yes, Your Honor.
Okay. I have a plea and sentencing agreement that calls for you to admit the violations in your two violations of probation cases, as well as plea to count one in the 2894 case. The state would null pros count two, and then it'd be all of the terms as announced by your lawyer, 17.4 months Department of Corrections, and then your fees and costs. Is that your understanding of the agreement? Did you have enough time to go over this agreement with your lawyer? Did you understand and sign the agreement? Are you satisfied with your attorney's advice and representation? Are you currently suffering from any mental health issues? Are you currently under the influence of any alcohol, drugs, or controlled substances? Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything other than the terms of the agreement that were announced by your attorney? Do you understand in the violation of probation cases, by admitting your violation, there won't be a hearing where the state will have to prove how you violated? And do you understand in the new case, by entering a plea of no contest to count one, that there won't be a trial of any kind? Do you understand that you're giving up your trial rights as indicated on page 1 and going on to page 2 of the agreement that you stated you understood and signed? And do you understand that you're waiving all potential defenses in all cases? And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country? And do you understand you'll be adjudicated as a felon in these cases? All right. Based on all that, what is your plea to the violations of probation in 24 CF 1357 and 1358? Are you admitting or denying that? All right, I'll accept your admission as freely, voluntarily, knowingly given. And what is your plea as to count 1 in 24 CF 2894? I'll accept your no contest plea as freely, voluntarily, knowingly given. State have an announcement on count 2.
It's count 2 would be dismissed.
All right, count 2 is dismissed. All right, on 24 CF 1357 and 1358, it's going to revoke and terminate your probation or supervision. $100 cost of prosecution times 2, 1 for each case. The $50 application fee. $100 cost of defense times 2, 1 for each. 17.4 months in the Department of Corrections with credit for all time served. Coterminous and concurrent, that's the state's agreement.
That is the state's agreement.
Okay. 24 CF 2894 may also be 17.4 months Department of Corrections, credit for all time served, 615 court costs, $100 cost of defense. That'll also be coterminous and concurrent with the 2 VOP cases. And adjudication of guilt on each case. Anything else for Mr. Moore? All right, Mr. Moore, I'll need your fingerprints before you leave. You have 30 days to appeal the judgment and sentence of the court. This is a slight downward departure from 19.65 months to 17.4 based on the legitimate uncoerced plea bargain.
I believe that's all I have. If 9 o'clock tomorrow for jury review?
SDRC, each count.
Each count, yes. Okay.
Scott, before you go, probation had a question on Hardy.
Mr. Nopes?
Sorry, Your Honor. This was a question for the court, for Mr.
Okay.
Hardy.
From Ms. Hardy. I didn't officially, but I will waive cost of supervision for Ms. Hardy due to the fact that she's indigent. Thank you. I'll just point out, I say it 100% of the time and that it's written down.
I was just telling probation, I said, one of these days I'm gonna
Go ahead, Mr. Nopes.
I've got Kyle Palmer, 26 CF 621. Judge, when he went to first appearance, the bond was set, and the condition of it was no contact with the alleged victim, which is a child that's 5 going on 6. And, but Judge Mason indicated that if, she made it sound like they were going to for sure, but I guess DCF has not opened a voluntary case or what have you. But if they were to make a suggestion, then pretrial would have the authority to modify the contact between Mr. Palmer, and this 5-year-old, 6-year-old child.
And no contact until DCF plan, and then contact consistent with DCF plan. What's the state's position?
The state objects to any contact whatsoever with minors and his kids, all of his children. Because there is a main primary victim, Maverick, but all other 3 children witnessed the abuse.
Right now, Judge, he's able to see the other children, just not the one.
Well, there has been a change, I guess, pursuant to an order of Judge Gonterek, Your Honor, on May 1st, in 25 DR 3857. There was an emergency petition to remove temporary time-sharing rights on the defendant based on a petition filed by Ms. Palmer, represented by Mr. Hardy. She swore in that petition that the changing condition has to do with the defendant's paramour, Sidney Rosario, who moved into the defendant's house. She has a pending child abuse case out of Nevada, where the allegations are that the charges stem from her breaking her children's elbows. She broke her son's elbow 2 times and daughter's elbow once in a 2-month period. She has locked her children in dog cages, tied their hands and feet behind their backs, and locked them in closets, and taped their mouths shut. She had run off and was in hiding with her son for a month, where her son had visible marks from her abuse on him. So this lady apparently resides with the defendant at this time, and the state is extremely concerned for the safety of those children. 1, because they're victims, 2, because they're also witnesses. And the possibility of intimidation, coaching, it's very, very great. They're very young. Alex is not even, I think, 2 years old. Then there is Holden, is 9, Maverick 5, and Kyla is 13.
Judge,
Just a second, Mr. Noble. I'll let you respond. I just want to finish reading something.
Sure.
Go ahead, Mr. Nopes.
So Judge, what Judge Gonterick did was he granted the emergency motion based upon the sworn, I guess, the mother in this case, and the parties are going through a divorce.
I see that.
Court realizes that or not, but.
I think it was just discussed, and I've just read it.
Yeah, it's normally how these things work, right? So the bottom line, judges, is that Judge Gonterick has signed the order not allowing him currently to be able to have unsupervised visitation. But he also said, or the JA, Cheryl Gary indicated that the matter's supposed to be set for an expedited hearing.
Okay.
My office has contacted Okaloosa County, Nevada. We can't get anybody to talk to us out there at the Parker Court. Nobody, I don't know, they've kind of got a different system. So I just wonder where this lady got this information allegedly from. I'm not saying that she didn't read it somewhere, but I don't necessarily know if it's true or not true. But once we get an expedited hearing, then Judge Gonterick can decide what to do. But in the meantime, I think this court ought to modify the bond conditions, because right now Judge Gonterick's keeping it at, supervised visitation at the visitation center.
It says for the minor children, right?
I'm looking at, I don't know exactly what the order says, Judge. I can't, sometimes the
It
clerk's
says
office.
paragraph 3 of the order says a petitioner/husband shall exercise supervised time sharing with the minor children at Safe Connections 2 times per week.
Right. That's what it says there.
Just, I guess to clarify, I am not asking to order contact pursuant to Judge Gonterick's order. The only reason why I argued to keep that into consideration is the additional concern that the state has. I'm asking no contact whatsoever during the pendency of the case.
To the victim.
To the victim and also witnesses who happen to be his own children.
Did you file a motion asking for that?
No, Your Honor, but I would have asked.
But can I change the bond in a way that restricts a defendant more unless the state's filed a motion?
I don't remember, the first appearance order, I'm trying to access it, Your
The
Honor.
box is checked, no contact with the victim, not to be within 500 feet of the victim's vehicle, residence, or place of employment, and there's an arrow going down where it says, until DCF plan, and then contact consistent with DCF plan.
So based on that, Your Honor, my argument with the victim would be that if there is no DCF, then there is no contact with the victim. And if the court is inclined, I understand, obviously, he would have to abide by the order of Judge Gonterick when it comes to the contact with the other minor children. So I understand the court's position, and I will follow up.
Again, I just don't think I can, it'd be like if he was asking for a bond reduction, and you said, well, I think it should be even higher. I can't change it unless there's been a kind of an opposing motion. So all I can do is basically based on Mr. Nopes' motion on behalf of Mr. Palmer to ease some restriction. I'm not going to do so at this time. Here's my first thought, and especially once I read your motion, Mr. Nopes, in that you were talking to the DCF investigator, which they typically don't talk to lawyers, has been my prior experience. And then decline further comment without providing a guidance or a projected timeline. DCF is required to close any investigation within 60 days. So, being that this happened, I don't know when DCF started, because the allegation here
November
is that it
23rd.
happened in November. My case, it wasn't open until March. So unless y'all have something to tell me differently, I don't know why a warrant wasn't sought until March 26th, 4 months later, but that certainly doesn't give me any indication as to whether or not DCF has completed its investigation. But as far as the other side, no, there's no pending dependency case, right?
That I know of, no, Your Honor.
First appearance was Saturday, the 28th of March.
Yes.
So,
So but a warrant doesn't seem to have been signed for about 4 months after the event, but that doesn't tell me when DCF started their investigation. If they started it once a warrant came out or he was arrested, then we're still within the 60 days. If they started it back in November, then obviously those 60 days are up, but I don't know that. So it's certainly something we can readdress. As far as the concerns about the emergency hearing in the dissolution case, y'all can bring it back anytime that other decisions are made and you want to present something to me. But as of right now, based on what I've read in the report, based on the fact that there's now other allegations, I understand that the current dissolution or family law court has said safe connections, supervised visitation. But until I know the extent of what that investigation is, I'm going to keep it where it's at with no contact, without prejudice to bring a new motion when things changes. And, that's the whole point of bond motions, and anytime there's a substantial change in circumstances, y'all can certainly bring it back. I think there being a resolution to that family law issue on the emergency order that was just signed this past week is potentially a change in circumstances, substantial change in circumstances, and also if DCF concludes its investigation would be potentially a substantial change in circumstances. But otherwise, at this time, denied.
So no contact with the actual alleged victim, even at safe connections, but he can see the other kids.
I'm not changing that because the court wasn't moved to do that. There's no restriction on the other kids in the criminal case as of right now, but the family law case controls that as far as the other
Yes.
children.
Yes, sir.
I think the way it really works is the most stringent restriction is what applies. So as far as to the actual alleged victim, there's no contact as to, and I'm not ordering this, I'm just explaining it as the way I see it. As the family law case has said on the other children, supervised contact only at safe connections. But that's what the emergency hearing will figure out once it's set in front of Judge Gunterick. All right, thank you, Mr. Nopes. All right. Do we have anyone else? All right, then we'll be adjourned until 1:30.
Thank you, I'll see you later.
All right, we'll see you then.
No, we don't. Oh.